Well, thank you everyone for joining us this evening at 5 St Ambrose Hill and our webinar this evening, which is entitled Hot Topics in Account Freezing and Forfeiture. My name is James Fletcher, and with me this evening is Barnaby Hone and Gemma Rose. We are asset, forfeiture and recovery specialists here at 5 St Andrews Hill. And what we're doing in this evening's webinar is to set out some of our thoughts from a practitioner point of view on what's been happening, areas and topics of interest in relation to account freezing and forfeiture applications. We are aiming for this webinar to be about 40 to 45 minutes in length. We've prepared some slides that set out in broad terms some of the things we want to highlight to you and which we hope will prompt a discussion at least amongst us. And at the end, if we've got some time, we will be able to take some questions. So if you do have any questions, please could we ask that you put them in the question and answer, the Q&A box, which is on your Zoom applications. Tess Aronofsky is helping us with the slides. And so we'll now move into the introduction, and I'll hand over for this part to Barnaby Hone.
Thank you, James. So AFOs have now become quite an established part of the asset recovery framework. They came into force on the 31st of January 2018, and they were quite an underrated part of the Criminal Finance Act 2017 at that point. UWOs, you might remember, were at the forefront of that package of materials, but AFOs, some commentators, did think that they would take off, simply because they filled a void. SARs, as they then were being reported in about 400,000 a year. But apart from pure civil recovery or prosecutions, there's very little that could be done with them. That's what AFOs were there to deal with, and they have. It has been slightly slow burn. They've developed over the last 2 years, but we're seeing a huge amount coming through now, and for very large amounts of money. The largest one has been in the tens of millions. I know that both me and James and Gemma have dealt with regularly £1 million cases, and we will expect that to continue. What we're also seeing is the legislation being updated. So it began with a very pure definition of what is a bank account, which proved to be a bit difficult because it didn't include companies such as TransferWise and other account holders. It only included pure bank accounts. I had some success in having them dismissed at that point, but then that was challenged. No, sorry, that wasn't challenged. That legislation was then changed, and we now have a much wider definition of what is a bank account. As we'll see later, this type of legislation is going to be used to deal with cryptocurrency, or should be, if the economic crime bill goes through in the manner that we expect. We'll deal with that partly later, and that will also be dealt with in a number of seminars we're doing in the new year. The scale of AFOs can also be put in context by who can make the application. Any approved financial investigators, anybody who's qualified through the course under section 354 of POCA can make an application. And to put that in context, I've made applications and defended against them both the NCA, for HMRC, police forces and serious crime police units, but also for groups such as local authorities.
Have you found, Barnaby, the knowledge of the applicants is consistent, or are some people more comfortable than others in terms of the applications?
Frankly, everybody is still getting to terms with them, I find, and there is a lot of gaps in knowledge. Hopefully we'll explore that. Some with time limits, which I know you're exploring next, but also with the basic rules, and there hasn't been a lot of case law on this, as we'll see. So I think there is quite a large knowledge gap, both with the courts and also some FIs. Some FIs have a particular specialism in them and are very good, but it's only now trickling down. And there are certain units that are being set up, such as Thames Valley's Southern Unit, which I helped form, and also the East of England, which I advised on. They've got quite a lot of expertise, but it is varied. I think, have you found that as well?
Yeah, definitely. Yeah. And I think it's useful. It can be a really useful tool for authorities. And I think as each authority becomes more and more familiar with them, then you see a rise in the applications because they're aware of another tool rather than prosecutions. It can be a lot quicker as a means of forfeiting money, such as cash accounts and so forth.
I think the NCA sum it up when they call it a disruption method, because it is. It also puts pressure on people, and it takes assets away when used with cash and asset seizures as well. But that gets on to my last point, which is court capacity, because something which will go into time limits. There doesn't seem to be a huge amount of court capacity, whereas extradition has their own courts for it and then specialist judges. There aren't in for account freezing orders. And I think that is quite a large issue. You're seeing Crown courts have specialist POCA judges for restraint orders. It would help if there was time given for these, simply because the expertise would then be concentrated, but also you would have guaranteed time rather than these being pushed to the back of the list, which I find happens quite regularly.
In terms of court capacity, one thing that I've noticed is as AFOs have got more complicated and wider in the approach of law enforcement seeking to freeze bank accounts, you are getting cases where respondents are coming to court saying, I'm just not ready to deal with this initial application. I need more time. But the court doesn't have the time. And of course, the applicant says the clock is running.
Yeah.
So I think it is a big problem in terms of what do you do in those circumstances? You know, do you try and negotiate effectively a short AFO and come back at a later time? But the difficulty there, of course, is the court still has to make a judgment. I don't know whether you found that problem.
I have, and that practically you normally make short time, but then are you conceding that there's reasonable grounds? It will be an area where there'll be a judicial review at some point, because the court should be able to give time for on-notice applications which are sufficient, which are normally 2 or 3 hours. I was in the largest case I dealt with, which was 250 million. We were given 3 hours to deal with the matter, but luckily the NCA had predicted that. I was defending, they were prosecuting, and they predicted that we needed that time, and the court worked with us. But that was in Westminster. I don't think you would get that service in other courts. Yeah. And it goes back to the next point. Next slide, if possible, Tess, is in the in the Ingleston case.
Well, this is a really new case, isn't it?
Yes.
So I mean, I don't know whether should we just explain the facts of the Ingleston case, because that's quite a good case on how the court should approach applications to set aside or vary AFOs. So in that case, in fact, it was two judicial reviews rolled into one, the National Crime Agency reviewing the decision of the court and a company reviewing the decision of the court. And the person behind it was someone who'd been sanctioned because of their links to Russia. But in the UK, they had some companies, and those companies were set up to pay family living expenses. And another one was set up for funding security for this person's family. And this person, P, had gone to the Treasury and got a license from the Treasury to allow him to pay school fees and to pay for some basic family needs. The National Crime Agency applied for a number of account freezing orders, and in due course, the companies applied to vary the orders to they said to put into effect the licenses that the Treasury had given them, and they also applied to set aside the AFOs at the same time. And there was then judicial review of the decision of the district judge, and the district judge had said, no, you need a change of circumstances to apply to set aside an AFO, which the High Court said, no, you don't. That's not part of the test. And a useful thing to note in relation to variations, the High Court said, you've got to really concentrate on the test, on the requirements for variation. It's not just some general discretion that the judge can use. So that's a useful case. And simply, it's not up to the judge just to rubber stamp the order.
And that's particularly important. It's not just for the judge to rubber stamp. We're seeing that a lot, that judges, lay panels of 3 or 2 justices are taking decisions which are quick and not drilling down to the actual points. There's also, I think we were discussing a case earlier of a judge who didn't he tell you that any decision to discharge should be judicial review? Yes,
in respect of whether the application in the beginning should have been ex parte or not, and the decisions that were made at that hearing. The judge refused to entertain any submissions on that when we were discussing whether the order should be set aside or not, and sort of limited the submissions that we were making. I think it goes back to the point that we were making earlier in terms of the variation of the way things are being dealt with in terms of court capacity, who are hearing them, the fact that there's no specialist sort of setup for it. It can really dictate a wide variety of things. So you're getting a large number of different decisions being made in lots of different ways because there is no concentration of those people making the decisions. And in terms of the expertise of people making those, you often find that you come across people who've never, dealing with lay benches that have never dealt with these applications.
Personally, I think the judge was wrong there. It is a possibility of a discharge, and also if you judicially reviewed it, the High Court could quite easily say, well, you have another remedy, and that remedy is discharge.
Yes.
Taking into consideration everything.
Gemma has raised here the issue of public ex parte hearings and private hearings, and that's another one we've got on the slide, isn't it?
Yes.
The Javidov case.
Well, going into that, the presumption is it should be in public. But in ex parte hearings, that's seen as a good grounds for there to be a private hearing. My view is ex parte should always be private. When it gets to public after that and is challenged, it goes into the public sphere. And unless there is an exceptional circumstances, otherwise that seems to be both a view in civil recovery, but also in these areas, such account freezing orders and cash. Is that your experience as well?
Javidov is a really interesting case, the way that the High Court goes through the requirements for having a private inter partes application. So the High Court said, look, there's a presumption that if you're applying without notice, the reason for that is you don't want to prejudice the court application for the AFO, because if the respondent knew, they could get the assets whipped away. So the High Court doesn't have much problem with that. But if you are inter partes, there's a much higher hurdle to deal with. And just being humiliated or having your name in the papers or having embarrassment at being linked to an investigation, even though it's only an investigation at the stage of an account freezing order, is not enough. So it's a high threshold if you're inter partes. Tess, could we have the next slide, please? So I'm just going to take over a bit and talk about something that I've become increasingly aware of over the last year or so, and that's really in relation to time limits and the importance for all practitioners to really be aware of the very tight time limits that apply in AFOs. And my first bullet point here is really just a matter of sort of interest. That under the cash regime, you could have someone could seize the cash and they had 48 hours to get to the magistrate's court to ask for an extension of time. There's no sort of trigger time limit for an AFO. You just apply to the court for an AFO. But it got me wondering as to whether Section 127 of the Magistrates Court Act applies, which is the limitation which applies for complaints, which says you've got to apply for your complaint within 6 months of the matter of the complaint arising. So I just wonder whether, if you've got an AFO situation, if someone says, well, I've got reasonable grounds to suspect, but I'm going to sit on it for 7 months. I wonder whether you could be out of time.
In my view, I think you could.
Yeah.
And it particularly applies to suspense accounts, is the first example I'd give. A lot of money has been seized by banks, put in large accounts, and is kept there. The claim, the money has been in that account for a long period of time, sometimes 15 years. Now, technically, that complaint has come about long before the 6 months period of time. And I think you could have a very interesting legal argument on that basis, because, as you know, this is due to the section, it is a complaint. It's not a criminal case. It is a complaint under the Magistrates Court rules, and it has that 6 month time limit. It'd be very interesting to see. I think that's going to be an area which can be challenged. There'll be one or two cases where old money is found in accounts traced to previous criminality and no action has been taken.
Yeah. Well, I mean, if people can see on the slide here, I've just reminded everyone that your account freezing order ceases to have effect at the end of the period specified in the order. So all your applications, if you're an applicant and you're asking for an extension of your AFO up to 2 years, has got to be granted within the existing period. And Barnaby's going to mention a case, a recent case about cash, but it's the reminder that you've got to get your application in and dealt with within the time. If you look at my little final bullet point here, just reminder about appeals. It can often catch people out who think that the same appeal regime applies to normal appeal from the Magistrates Court to the Crown Court, that you can get extensions of time. The legislation is firm that you've got 30 days and the appeal must be made before the end of that 30 days, starting with the day on which the court made the decision. Tess, if we could have the next slide. So there was quite an interesting case called Malin last year, where the Court of Appeal dealt with a public law attack against a decision in the Crown Court. But the background to that was Mr. Malin had a account forfeiture order made against him it was the 30th of October of 2019, and he wrote an appeal form, sent it to the Magistrates Court on the 29th of November of 2019. So I think that was within the 30 days. But the Chief Constable of Lancashire said that the appeal was out of time because it didn't comply with the Crown Court rules, which required the other person to be given notice, and they didn't get notice till December. So they said, you're out of time. In the Crown Court said, well, we think the appeal can proceed, but the Crown Court made that decision without inviting submissions from any of the parties. That led to the Chief Constable asking the Crown Court to state a case as to whether they'd erred in law. The Crown Court said no, so the Chief Constable judicially reviewed the Crown Court, and it all went up to the High Court, and the High Court basically said, this judicial review, you brought it too late, so we're going to refuse it. You need to go back to the Crown Court and discuss your case management issues and an extension. You can ask for an extension of time for your appeal in the Crown Court. And that, I thought that was interesting because the Crown Court didn't mention, and neither did the High Court mention this, the second case we've got here at the bottom of this slide, which is Lamai, which was a cash case, but is authority for the fact that that 30-day time limit is finite and you can't extend it. So I'd be interested to know what actually happened once this has got back to the Preston Crown Court to see what actually happened. So yeah, there we go. Well, Tess, could you give us the next slide?
This is Man, which I was involved in the tail end of. It was a case where the prosecution had applied within time to extend the cash seizure order, the cash detention order. Due to COVID, it wasn't heard within the time. The question is, was that fine? Could it be extended? Or was that time limit finite? The court found very clearly that the time limit was finite. And despite the fact that HMRC was acting in good faith, that did not matter. There was strict timelines. And that then follows in with the earlier cases we've discussed. What is also interesting about this is then there was some re-seizures afterwards. That's the bit I was dealt with. And those re-seizures took place, and the magistrates court then threw out the matter on the fact that it was abuse of process, because in essence, they were trying to get round the fact that there had been a challenge to initial detention. Though, if that was the other way for them to do it, was just to make an application for forfeiture in the time limit. So while the time was running, they could have made an application for forfeiture and there wouldn't have been an issue. There could have been a challenge to the forfeiture that there's lack of evidence and the matter might have been hurried on. But it's an interesting case to highlight the strict time limits which are enforced, B, also to look at what are the ways around it. And the fact that blaming the court is not something which is going to go down well at all. It's not going to work. And that's what we found. One of the problems we've all discussed earlier is the courts are under-resourced. So we need to be able to be aware of that and be aware of these strict time limits. Something I found is in variation applications, you need 7 days notice. Often that's not made, and I've had variations dismissed on that basis. I don't know if you've been involved in those quite large cases. So it's knowing the rules, knowing and making sure service is also correct. Service needs to be in the correct manner, not 24 hours beforehand in person. So it's being aware of these rules because they're being interpreted in a very stark way. The last thing I'll mention on this point is that AFOs are slightly different from cash in that you have 2 distinct periods of cash. You have the detention period and then the seizure period. Under section 303Z14 with AFOs, the freezing order continues, so there can still be variations while the forfeiture application is being heard, which allows exclusions and other points, which we'll discuss later.
Can we just mention something useful to remember? There's one type of time limit which is more flexible, and that's where there's been an administrative forfeiture. Where no one has come along and someone higher up in law enforcement says, well, I'm going to make a decision myself that this is going to be forfeited, and no one appeals that decision within a certain period of time and it becomes forfeited. There is an ability under section 303Z12, I think, to set aside an administrative forfeiture, and you can do that after the 30-day period, can't you?
Yes, and as long as there is good grounds for you not to make that challenge beforehand. It does leave the forfeiture quite up in the air, which could be quite problematic.
I mean, is it right that you can set aside an administrative forfeiture if you've got exceptional reasons, but you can't touch a proper forfeiture? It seems that there's a bit of an anomaly there between the two sets of bits of the statute.
It does, and the whole process around notice and forfeitures on notice has got quite a lot of anomalies. That, and also challenges within 28 days. If there's a challenge within 28 days, it's null and void. And that can lead to difficulties if you're at the end of your 2 years. But going back to that, yes, there's these anomalies. That's something which needs to be grappled in both the High Court and also potentially with amendments to the statute. Why it was there, looking at Hansard, is to deal with cases, particularly abroad, where you make a forfeiture and people haven't been given correct notice. And they might have an interest in that money, but due to, say, fraud or due to the lack of being able to register that, they haven't been put in contact with. It leads to quite an interesting and definite debate about what is an interested party. The moment interested party is anybody who comes forward or can be identified. We don't have a stronger definition of that, and it would be hard to define that. So that's why it's there, but it is going to lead to problems. Shall we go on to the next slide?
Yeah. So I'm just going to talk about one of the things that I think we've all come across and experienced are that there can be real benefits of engaging early with authorities who are applying for these orders. Once orders have been made, maybe approached by a client, and I think it's been very useful to try and find out who the officer dealing with it is, to create a relationship with them. And I've certainly been involved in cases where we've built quite a good rapport with the officer, and when we've then provided information, it's been considered seriously, reviewed, and that's resulted in orders being withdrawn. So I think sometimes, obviously there are different approaches. It depends whether you want a strong approach but sometimes a more considered, slow approach can work. But again, it may depend on your application, depend on your client, variety of different things. But it's important to work out really what are the priorities of the authority. And there may be certain things that they are keener to have information on than others. And so if you can work that out early on, it's a good way of identifying what further information you might need to, or what you could provide at an early stage while things are being investigated, which then could have the result of orders being withdrawn potentially, because the authorities are somewhat more satisfied with the response that they're getting. But it can be quite a fine line you need to balance. And again, that will depend on your client and the circumstances. There may be certain things that you have, business records, loan agreements, so forth, that you don't necessarily perhaps want to provide in a huge amount of detail. It's important to balance, obviously, explaining transactions whilst also not setting off something else that they can look into and investigate.
But it's also especially bearing in mind that the next hearing is going to be public.
Yes.
So what you don't want is to provide too much information which might be sensitive and often commercially sensitive. It is not just about the illegality that might be there. There's a lot of commercial sensitive banking records which could be put forward. In my view, it's useful to have representation at the first hearing so that you can start talking to the officer, open up that line of communication, and also see what their main points of reference are. A good information assists with that, and an officer who's prepared that allows you to respond to that. One of the problems with information is there's still a lack of understanding about the fact that it needs to be served with the note order sometimes. Goes back to our issue that we had of not all people, AFIs, have complete understanding of there. And second, also the fact that sometimes there is redactions. Now, I know we've discussed this, but I can't see any easy way to law that allows you to redact an information. So without that, that's opening up prosecutors, authorities to an easy challenge because they're not being clear. And an ex parte application needs to be clear, needs to put all the information forward.
Knowing how much you are going to engage at the early stage for the benefit of your client as a respondent is sort of a judgment call, isn't it?
Yes.
Yeah. I mean, I've certainly found that in certain cases you can have a willing respondent who provides information, but what that just prompts is a further lines or questions from law enforcement They're basically asking more and more questions, and then it becomes a bit sort of tit for tat.
My advice there is always to have the threat of a discharge application and be ready to go with that. You have to balance the response. I did a case recently down in South Wales where we put in a response, but we made it clear that if there wasn't a clear response to that within 21 days, we would go for discharge. What we didn't want to happen was this back and forth, which is an extension. That doesn't mean that we wouldn't happily fight the discharge or that there might not be some legitimate questions, but you want to get that fine line and also put the other side under pressure so that there is a decision rather than fifth-faffing.
Yeah.
Well, otherwise, I think from a respondent point of view, you do get the feeling sometimes that law enforcement who are just corresponding, litigated by correspondence, can sometimes you just get the feeling that they're perhaps just fishing. And
sometimes it's never enough information. You can provide all this stuff. So I think obviously it helps if you're communicating with your officer, you know, or the financial investigator, you know what they are looking for, or it's easier to pinpoint what they're looking for.
What about settlements here? We've got our final bullet point, settlements. What do we think? Can we settle AFOs?
Yes, would be my answer. I did 2 last week, so I hope that you can.
We hope you can.
You can have an agreement on the basis that certain money is to be forfeited and certain money is not. The basis of that agreement can be as varied as you don't have knowledge of that money, you accept that money is illegitimate for some reason, or indeed that you don't have authority over it. The case I'm doing tomorrow morning, we have varied it so that a loan is repaid, which was taken out fraudulently in my client's name. The rest of the money we have no link to. It was put in a bank account which was operated under our name, but it's agreed not to be our name. That will be made clear in the court. My client's position will be protected, the money will be forfeited, and he will no longer be liable for the bounce back loan. So you can, it's a very factual basis, but it does occur much more than in cash cases in my experience.
I think what you've got to, I think you can settle, but I think the parties need to remember that the court's decision is only to decide whether all or any part of the balance of the account can be forfeited. So you can't just settle a case and then ask the court to deal with it on the paper. Ultimately, you still have to give the evidence because the rule says that the application has to be made on oath. So you still have to go before the court, and theoretically the court could say, it doesn't matter what you guys agree, I'm not satisfied with this, the proceeds of crime. I've never had that, but it's a theoretical possibility.
James, please, let's not tempt fate.
No.
Let's also not give certain district judges ideas of what they should be doing. That would be particularly difficult, in my view. This has to be a pragmatic area because there's going to be a lot of areas where the evidence is not as strong. There might be some strong evidence on certain bits, and there will be fundamentally commercial cases. What I agree with all that you said, but I wouldn't put too much emphasis on the fact that you need clear-cut decisions. Sometimes there will be pragmatic decisions taking the evidence into account.
Yeah, I mean, I've got to say that I've never been involved in a case where the parties have agreed that some of the money should be forfeited and some should be returned, where a court has said, I'm disagreeing with the parties.
Neither have I.
But you never know.
Those are the cases which sometimes keep me up at night.
Yeah.
So shall we go on to...
Next slide.
So another thing that's useful to note is obviously in terms of freezing orders, there can be certain exclusions made because the order ordinarily freezes the whole account, but subject to exclusions. And one of those, they can be for living expenses or to carry on businesses, trades, but also an important avenue is legal expenses. Obviously, if someone's having their main account frozen, it's going to impact on them being able to engage at the proceedings and instruct lawyers to deal with the matter on their behalf. So there are applications that can be made, and the slide obviously sets out some of those details, which were in 303Z 5. And in terms of the cost, the things that is important to note are they have to be reasonable expenses and reasonably incurred. So quite often they involve courts looking into what these costs, how these have mounted up, what work has been done, why has it been done. So there may need to be a level of explanation given for those costs, because the balancing exercise that has to be done is whether the exclusion is going to unduly prejudice any subsequent forfeiture application. And I think a lot of, when I've dealt with them, a lot of the time it comes down to essentially the court looking at the value of the costs, looking at the value of the account and doing some sort of balancing exercise in that sense as to, yes, of course, the desirability of someone being represented, but also if the cost application is too high, they're simply not going to grant it if it's going to wipe out the entirety or a high proportion of the balance of the account. So sometimes the cost applications will depend on the value, I think, and how high it is in comparison to the account.
See, I disagree with that. That is, don't disagree is the wrong word, but I think there is a line there of, is it worth actually making an application in the first place for the prosecuting authority? Because there needs to be an ability to defend. So if somebody has £1 million and they're defending a £20,000 order, of course, that order isn't going to be granted. But if that's the only money they have, then I have a case where we in essence used all the money and then we made an application for costs because we couldn't defend it with anything else and the person was going to be left destitute. So
it seems the legislation sort of set up in the other way, though.
Yes.
It's sort of the presumption is that it's looking at it from a prosecutor's point of view rather than sort of the ability for people to defend themselves.
Well, I think it's working on the basis that the AFO is preventing any person from dealing with a specific bank account. So I think the legislation is set up to say, well, you know, unless you can show that you require it, we presume that you can fund it from somewhere else. So it's a sort of the other assets argument that you get from some of the civil recovery cases like Azam. I mean, it's again, practitioners will find it useful to read the Ingliston case,
yes,
because there is reference there, and the court emphasises that you've got to look at the test in detail.
I've always seen it, and probably because quite a lot of my work is defence, from a slightly more defence-minded view, because though you've got to look at all the assets, in particular, in cases such as this, you're seeing a large amount of accounts frozen and all their accounts and access. So it gets to have a quite similar to a restraint order feel, rather than necessarily to Azam or civil recovery, where you're aiming at one or two large assets and allowing the bank flows to continue. It is certainly a difficult area, and we're seeing quite a lot of different responses. But one of the things which particularly heartens me is that there is often an open discussion about this. And sometimes I've had cases which are practical decisions have been reached because there's not enough money in the bank accounts to have legal expenses, and deals have been done that way.
Yeah.
It's still an area which is evolving.
Can we move on to the next slide, please, Tess? So the next topic, we just want to cover something that is becoming increasingly important to respondents, I think, as these sorts of applications get more complicated. And it's really about, the disclosure regime, or what disclosure regime, perhaps, in account freezing and account forfeiture applications. There are a lack of applicable disclosure rules. So the civil procedure rules don't apply because the proceedings are taking place in the magistrate's court, so it's not the High Court or the county court. And the CPIA, as far as criminal disclosure, doesn't apply because these are in rem proceedings against balances of bank accounts rather than people, and these aren't criminal proceedings. So neither of them apply. Well, what about the magistrates' court rules themselves? Well, they are completely silent. They don't set out any sort of disclosure regime. So, is there a disclosure obligation? I think there is a disclosure obligation. You can't tell the court things that are not accurate, and you have to tell the court if you've got something that undermines your case. So I think there's got to be some sort of disclosure obligation, but the question is, what is it? What's the extent of it? And if it applies to the applicant, does the respondent have disclosure obligations as well? I mean, I can't imagine that respondents would want to have disclosure obligations like standard disclosure or anything like that. So it's an interesting, we've not had a case on what exact disclosure obligations there are. There's been a case that's referenced disclosure obligations, and that's the Hack case at the bottom of the slide. That was a case which went on judicial review, and in the course of the judgment, the High Court mentioned a passing reference to disclosure, but made no ruling on it. Essentially, Mr. Hack raised some disclosure issues in relation to some telephone downloads of to other people who were effectively couriering cash out, a large sum of cash that had been seized. And there were concerns, his legal team had raised concerns as to a schedule of the telecommunications between those people and whether it accurately set out what was on those messages. And in the course of the High Court proceedings, and the reference is there if you want to have a look at it, the NCA said that the disclosure regime that they had applied was basically Section 3 CPIA. So in terms of their unused material, did they have anything that undermined their case or assisted the case of the respondent? So that's what the NCA did in that case. But in terms of ex parte applications, if you look, or not even ex parte applications, often informations in general, they often now carry a section that says duty of full and frank disclosure or duty of candor, setting out things that the applicant is bringing to the court's attention which are relevant to the issues. And then another thing, final thing on this slide, just to think about, is the fact that the rules do say that the case management proceeding, the court can give directions as to the management of the proceedings. And one query might be, does that give the court breadth to make disclosure orders? My personal view is that that's really talking about the fixing of the case, or maybe listing a CMC or something like that.
Fixing and listing of the case, I don't think that gives them extra judicial powers to make disclosure orders. I'd agree that a sensible procedure is as the NCA followed. And as a prosecutor, you want to come with clean hands. You do not want to be seen to be hiding matters. I don't think there's a burden on the defence. That's an evidential issue largely. And if they have material, that will be tested. It gets more interesting if the defendant is an institution, as we sometimes see, or a company. But that can be dealt with as a matter of course in litigation.
Yeah, but I don't think it's possible for respondents to seek disclosure orders.
No.
So really, it's a very firm focus on the applicant to make sure that they're bringing everything to the attention of the court that they should.
It's also how I deal with it, and come in, if you disagree, is to put the focus on them in cross-examination and testing the evidence, because often there will be issues which clearly link to some disclosure. If that's not there, that undermines the case.
Yeah.
How have you found that?
Yeah, no, I think questioning of the officer is always key in these applications, and obviously exploring the parameters of the investigation, how much, digging into everything that they've done. I think there's also sometimes an interesting crossover between competing sort of criminal investigations and obviously these civil applications. And so I think it can be a balancing exercise for prosecutors to work out how much of the information from criminal investigations they are able or want to disclose, as part of these proceedings.
That's a core point, and it's undermined a lot of investigations because there was an idea due to Harvey Payton and others that these investigations should wait. I think that's misguided, and the High Court has clearly shown that unless there's very good reasons, that wasn't exactly the test, but unless there is, shows that there can be something which would severely prejudice the parties, it should be continued and civil proceedings should run.
You've got to have, if you're going to do that, and you're representing the applicant, you've got to make sure that you're fully aware of what's happening in the Crown Court, and you've got someone who can say, this is a relevant thing for your case, and you have to give it to the other side. And
that has to be done. And this is, okay, I've seen a number of issues where prosecuting authorities come trying to push the case, as they should, but they haven't done their disclosure.
But if I were a respondent and I was under criminal investigation, I wouldn't want to have an AFO, live AFO against me, where I was basically being asked to provide an explanation for money in account.
You don't want to provide that evidence. And go on,
you might not, but you might also see it as a way to get the AFO dismissed if there's a disclosure issue, which there often will be if that hasn't been taken into consideration. And that's not saying I would advise continue down that route, but it does provide difficulties for both parties.
Well, let's look at the next slide. This is basically the last main slide before we touch very, very lightly on some things that might happen. But this is about compensation and third parties.
Well, the point here is that there is at the moment no provision for victims and compensation. The only route is for variation, and often the court is open to this. And indeed, when prosecuting, I look at ways to return the money to interested parties if that money has come from a fraud. Is that your experience of it?
Yeah, I totally agree. It's very difficult because basically, if the court says it's the proceeds of crime, it's got to be sent to the consolidated fund. It goes to the Treasury. If it's not, your AFO is released and it goes back to the account holder, and they can do what they want with it.
Yes.
So this is why there might be a revision. If we presume there will be.
And I think authorities then have to make that tactical decision in terms of when they're looking at all the tools that they can pursue in terms of proceeds of crime applications, and which is going to be able. Sometimes it does come down to how can they compensate people in terms of which tools they can use.
Well, the line that I've used is section 203Z4, and then vary that back to interested parties and give them a divided share. But that doesn't mean that they have been involved. Indeed, the first forfeiture in the country was me doing that in a romance fraud worth about £4,000. But some courts have found that less palatable. I disagree with the position. And that is why this revision hopefully will be useful.
Yeah, it's been fun so far.
Yes, that's what I was avoiding.
Yeah, but the new variation brought in by the Economic Crime Act, which will likely come in, is there at the very bottom there. So we're going to have some victim possibility.
We have a number of slides dealing with crypto. This is the cryptocurrency legislation which will come in, which will sit next to AFOs. We're going to be doing quite a few seminars on this when it's developed, come out of committee stage, which is in at the moment, and then when it is enacted. So I'm not going to spend too much time on that. And the last slide, Tess, if you could just go through our interesting points. This relates to how money laundering has been used as a criminal type under Angus, and also then how money is sometimes used, how the second limb is increasingly being used, that being the money is going to be, or the account balance is going to be used in unlawful conduct. That's Fletcher and Sandy. But let's just move on. That's a sort of bare bones approach. I think we'll probably have another seminar on that and the development in the law in that. Let's move to the question and answer session, because we've had a couple of questions, and I know time is now running to an end. So if we just go through a couple of those. The first question I'll put is, Does the information, when we're talking about an AFO, does the information as well as the order have to be served on all parties, including the financial institution?
The information probably doesn't need to be served on the financial institution, I wouldn't have thought. Certainly the application has to be.
Yes.
And, you know, the information is going to be a court document. So that I would think, you know, we'll have to give that to the respondent. Certainly, and it shouldn't have anything in there that you wouldn't want the respondent to see. I think this harks back to a point that Barnaby was making about, you know, can you redact things in an AFO? And well, you better go and get the court's permission if you're going to do that. But really, you should try, you know, law enforcement should not be redacting things in an AFO, because it's very difficult for a respondent to understand the case they've got to meet if they want to try and ask for a discharge, if parts of the application are, you know, are hidden from them. So, no, I think you've got to serve the information.
Indeed, I agree. You have to serve the information. It has to be served on all interested parties, and it's an open document, and it also needs to be thorough.
Yeah.
The other point I'd mentioned going back earlier is, from a defence point of view, using the opportunity to cross-examine the AFI is always useful in variation and other applications in getting information.
Yeah.
So going on to a couple of other questions, looking at defending AFOs with overseas companies or overseas individuals, is there any particular characteristics or particular points you would bear in mind when doing that?
Just bear in mind, I think that, you know, if you're dealing with respondents or companies that are based overseas, don't automatically assume that you can get live video links to link them in. It depends what the position is in that jurisdiction as to whether they allow the UK to receive local evidence into UK courts. So, you know, you have to check for that. But otherwise, it's, you know, the key thing is where the account is located. As long as jurisdiction is based on where the account is, where the authorised deposit taker is based, not where the where the company, you know, who's the respondent may be.
Yes, so it is very wide.
Yeah, no, yeah, they can be variable.
And that's going to be an interesting bit with cryptocurrency, how wide that, how that does increase. Now, there's quite a few questions over disclosure and comments on that. And I think we've covered that. Yes, it is a difficulty. Yes, it would be more useful to have clear rules on it. But as we've said, it's an issue which will be explored in the court soon. The last point I'll just take is, what obligations does a respondent have for providing their means when they're applying for legal living expenses? These are covered in the civil recovery rules on living expenses, and those have been imported from civil recovery to AFOs. They're extensive. You need to provide a means form, you need to set out what your means are, and also what those expenses are going to be, and there has to be detail given. Some of those rules are taken from restraint orders, but it is something which is often a pitfall of respondents coming into applications, providing little information, expecting to get living expenses or to get legal expenses at higher rates than not the rates set out in that application. There's also, these will almost certainly be approved by judges, and the judges will put these applications under a lot of scrutiny, as Gemma and James both mentioned. So I would always caution advice, needed for advice, and need for the application to be strong and made once, rather than having a ping pong effect which then lose trust both with the AFI and with the court. Is there anything you want to add on that?
I think that this is one of those bits where the variation, especially for legal expenses, has been imported from the civil recovery practice direction. So the civil recovery practice direction and the civil recovery costs in proceedings set out, for example, the rates of pay that that solicitors are entitled to have based on their location and their hourly rates. The practice direction says that normally if you get a property freezing order, you can have a £3,000 exclusion for initial legal advice. And it also says that if you want to apply for an exclusion, you have to provide a statement of assets. Now that appears to have been imported into this regime, and I think the best engagement you can get with that is the best, because you're much more likely to persuade law enforcement to agree to a variation to release some money for, let's say, legal expenses or living expenses, if you can satisfy them that you really need the money from the frozen account and that it's in such an amount that's not going to unduly prejudice the application that may come, when balanced against the need for you to be represented and to be able to carry on your reasonable lifestyle.
And just following on that, Cinda Nichols has asked us about how the justifiable points that Gemma raised, and I agree. That's the line where you have to draw what is justifiable.
Mm-hmm.
It can't be, if somebody has £1 million sitting in an account, 50,000 being seized, they're not going to get legal expenses from that. And that's where the paperwork comes in as well, having to provide that paperwork. So it is going to be a point of contention, but I would approach it with as reasonable as you can be on both sides. And that often is by being open-handed. That's sometimes a difficulty for respondents.
Yeah, it's about being as thorough as you can, sort of within reason of what you want to, disclose to authorities. But if there are, I think I've normally found it, if there are avenues which you don't really want to disclose to authorities, normally there are some other funds or assets that perhaps can be utilised.
Yeah, I mean, it's an interesting. It's an interesting position. I certainly think in terms of the legal fees that you can charge, if High Court civil recovery sets out what hourly rates are allowed, then I think that it would be hard pushed to find a district judge who will say, well, in the magistrate's court, I'll allow you twice as much for an hourly rate. So I think that can give respondents a good steer on what would be a reasonable amount.
I follow those restrictions with hourly amounts. You also have to be particularly sensible. If there's a line that in the regulations that you can go to a cost judge if you don't agree with it. It's about being realistic of what hours you have.
And what type of fee earner as well can do certain different types of work. Obviously, courts will also scrutinise, whether some level of work needs to be done by the top grade fee earner, or it can be done by a lower level, which may attract a lower hourly rate. So there's lots of variety of things that the court will look at when they're looking at whether the costs are reasonable and reasonably incurred.
We're coming to the end now. So before I hand over to James for the final part, last question, there was a question of whether a notice can be applied for before, if you've only got 30 days left in the account freezing order. Now that is quite an interesting point. The difficulty there particularly is if it's challenged, then you're probably out of time. So I would just be very careful about where you are and when you're applying for the notice. The rest of the questions I will try and answer shortly on type. I'm afraid we haven't been able to go through them all, even though we're now 15 minutes over. So thank you everybody for your patience. And James.
Yeah, thank you very much, everybody. We hope you found that useful. It was a very quick canter through some of the things that we thought have been hot topics. If you've applied to join the webinar, then you'll receive the slides. Our test will be sending you out a copy of the slides, and we will endeavour to send that to you as soon as possible. We may not have been able to deal with everyone's questions. Of course, we are well able to field any questions at a later date, should you so wish to instruct us to do so. So thank you very much for attending this evening, and it's good night from us. Thanks.
Take care.
Thank you.